Hello, I'm Robert Proctor, outside general counsel for the Wisconsin Builders Association. And I'm very excited to tell you about the recent court decision in the Wisconsin Builders Association versus the Village of Sussex. The Village of Sussex is a municipality in southeastern Wisconsin, part of the Metropolitan Builders Association jurisdiction, that has been ignoring state law regarding the approval of subdivision plats. For a number of years, the Wisconsin Builders Association has worked with the state legislatures and the governor to refine the law on how subdivision plats are approved. A number of those changes include how surety is done. So, for example, when a member or any developer would go to have a subdivision plat approved to create a subdivision, the municipalities often require that they provide a letter of credit or some other form of surety to make sure that all of the public infrastructure is installed and installed correctly, which makes sense. Unfortunately, many of these municipalities go way beyond what is necessary to protect the public. And this creates a significant issue for developers. In an era of affordability, problems with affordability, the last thing that the public can afford is to have municipalities tacking on unnecessary large expenses that get passed on to the homeowner. So in laying out a legislative scheme for approval of subdivision plats, the legislature passed certain rules providing that municipalities may require a developer to put up a letter of credit or a bond at the developer's choice to ensure that the public improvements have been installed. And the amount of that letter of credit or bond can be no more than 120% of the estimated costs of the public facilities, the infrastructure. In addition, they can require that the surety, whether it be the letter of credit or a bond, be held for up to 14 months after substantial completion. However, once there is substantial completion, the letter of credit or bond has to be reduced to an amount equal to the actual cost of what items are left to be built plus 10%. So this is a way there was a way for the state to set parameters to make sure that municipalities could be protected, to make sure that all of the infrastructure was installed as part of a subdivision, but also to put limits on this what's really a transaction cost that gets passed on to the homeowners. Prior to the statute, many municipalities would require far in excess of 120% of the actual cost, would require letters of credit, and would require that the surety be in place for 2, 3, 4 years, whatever they decided. But after the law, many municipalities have come around to follow the law. Unfortunately, the Village of Sussex is not one of them. The Village of Sussex has an ordinance that says that the developer who asks for subdivision approval must enter into a developer agreement, and as part of that developer agreement, they will be required to provide a letter of credit. They are not given the option of providing a bond, which is required by the statute, and that it will be an amount that satisfies the village engineer or the village, and in a form of a letter of credit that satisfies the village attorney, and will be held for 2 years, maybe more. The WBA, Wisconsin Builders Association, and the Metropolitan Builders Association reached out with the Village of Sussex to work with them on this and say, listen, your ordinance and how you've been applying it to developers doesn't comply with the statute. Unfortunately, the village sent back a rather threatening letter, in essence saying that their attorney had informed them that these requirements are part of a development agreement, and that the development agreement that they require the developers to sign trumps state law, which is not true. And so the WBA decided to go to court to ask a court to rule on the issue of whether or not the Village of Sussex had to follow state law, and whether or not the developer's agreement that they required builders to sign would trump state law. And just recently, we received the decision from the judge that was assigned the case in Waukesha County, and it was an overwhelming victory for the Wisconsin Builders Association and its members. The judge ruled that the plain language of the statute absolutely required that the village could only require surety in the amount of 120% of the estimated improvements and no more, that they couldn't hold it for longer than the 14 months from substantial completion, that it had to be reduced to an amount that equaled the actual costs of the public improvements plus 10% at the time of substantial completion, and that they had to allow for either a bond or a letter of credit. The judge went on to state that any provisions in the village's ordinance that are contrary to the statute are unenforceable by the village, and also went on to issue an injunction ruling that the village can no longer ordering them to stop and no longer hold letters of credit or bonds to surety longer than the time limit prescribed in the statute. So obviously the Wisconsin Builders Association was very happy with the decision. We think that it just goes to show how hard the association works for our members to make sure that we coming together, the membership, can protect both the public from these unnecessary costs that drive up housing, and our members from who have to go through the process of trying to comply with state law and local municipalities. It was a great win, and we're very happy to share this result with you. Thank you.